All right, welcome back. It's still the Breakfast Diary at Odenigbo 99.1 FM this Friday morning. Still keeping tabs on developments in and around the country, trying as much as possible to make sense of them. Thank you for staying tuned. We're back with our topic of discussion for today, which is understanding the Nnamdi Kanu case, the legal perspective. Understanding the Nnamdi Kanu case, the legal perspective. Well, yesterday, Thursday, made it exactly a week since the Federal High Court in Abuja convicted and sentenced the IPOB leader, Nnamdi Kanu, to life imprisonment on terrorism-related charges. Justice James Omotosho found Kanu guilty on all 7 counts, including incitement of violence through broadcast, leading a proscribed organization, and issuing stay-at-home orders that disrupted public safety and attacked security forces and civilians. The court sentenced him to life imprisonment for counts 1, 2, 4, 5, and 6. For count 3, he received a 20-year prison term. For count 7, he was sentenced to 5 years imprisonment with no option of fine. All sentences are to run concurrently. The judgment has since generated reactions across the country and beyond, not only because of who's involved, but because of what the case represents for law, justice, and national security. Kanu's trial dates back almost a decade from the initial arrest in 2015 to bail in 2017, to the military raid in Afaruku, to his exit from the country, and to his controversial return from Kenya in 2021. Every step in the timeline has been contested, from the legality of his arrest to the fairness of his detention to the admissibility of evidence and the nature of the charges. The case has also evolved alongside wider national tensions, the agitation for self-determination, the accusations of human rights abuses, the rise of violent and non-violent secessionist activities in the southeast. The government's clampdown and the heavy security operations are followed. To many, the trial is about national security. To others, it is about political freedom and the constitutional limits of the state. Now, with a life sentence on the table, the country faces new questions, not about whether one supports or opposes Kanu, but about whether Nigeria has followed a process that protects the rule of law, whether the evidence presented met the legal standard, whether the return from Kenya has any bearing on the validity of the trial, and what constitutional options still exist from this point. And so in today's discussion segment, we want to understand the legal argument. What does the law say? What does the Constitution allow? What can the appellate court review? And what does this moment mean for Nigeria's justice system moving forward? My name is Njideka. I'm here with the analyst Nelson Way, as the co-anchor Favor Gilbert is unavoidably absent. But joining us to discuss this important issue is constitutional lawyer, Barrister Evans Ufeli, who joins us virtually. I don't know if he can hear me. Is he still on the line? Good morning, Barrister Ufeli. Thank you for joining us. There is something I really want to find out from you, because you have been monitoring the case right from the onset. From 2015 up to this very moment. As a constitutional lawyer, what were your projections as we traveled with the case in the 10-year period? Did it meet with your expectation in terms of the guilty verdict?
Yeah, you asked me whether the projection and expectations in the case was it met and the rest of that.
Right.
I'm saying that if you have been trained in the law and you know the law, settlement apart, under criminal proceedings, there are certain thresholds that must be met that are fundamental. Okay? And if those thresholds are not met, it therefore means that whatever judgment that is entered or delivered, in the absence of those thresholds, will go to no issue. No matter how high profile the case is, no matter the judge involved, the law is the law. Okay? To start with, in Nnamdi Kanu's case, at the point at which that judgment was arrived at, there was no valid law, there was no living law. If you look at section 36 of the 1999 Constitution as amended, It says that no one shall be convicted in Nigeria by any law that is not in existence at the time of the said conviction. So when you look at it, the law under which Nnamdi Kanu was charged, was the Terrorism Prevention Act of 2013-2015, which was amended thereafter.
Yeah.
And when those laws were amended in 2022, the prosecution did not amend the charge to reflect the new law.
Okay.
So all the while, when this matter was ongoing and all that, they predicated that trial on a repealed law. So as long as the law is repealed under which he was tried, it means that they are trying under nothing. Ex nihilo. So from nothing comes nothing. It's a principle of law. Ex nihilo nihil fit. Okay. So when you try somebody on a defective statute, okay, the defect in that statute or the absence of a statutory living statutory law means that the conviction is defective and faulty. Okay, that's one of the grounds. Another ground is that under criminal law, the standard of proof is beyond reasonable doubt. Standard of proof is beyond reasonable doubt. This is elementary law. For you to convict a defendant or an accused person, the proof must be beyond reasonable doubt. And that is that. If you look at the case on that, they say he made broadcasts from wherever. He made broadcasts from England, he made broadcasts through radio, through whatever it is and all that. And you, according to you, say that broadcast led to inciting the people. Yeah. And it led to killing policemen during the NSAS and soldiers in the east and whatever it is you say all that. In doing that, you didn't call one witness, somebody who was affected, or somebody who was a relative of somebody affected, or the policemen and the soldiers that were killed don't have relatives that could testify that truly it was after the broadcast that that led to the mob action that led to the demise of their loved one and the rest of that. No witness was called to testify. Okay. So you couldn't have reached a conclusion in a criminal matter that requires capital punishment without proving those allegations beyond reasonable doubt. Assuming but not considering that Nnamdi Kanu won't enter the defense. Okay, because he didn't even enter the defense, that's the issue there. But even if he did not enter defense, the prosecution still didn't prove his case. Okay. The prosecution is supposed to rely on the strength of his case and not the weakness of the defendant's case. We are not supposed to convict solely because the defendant did not enter defense. No. The court is supposed to convict on the strength of the prosecution's case even without the defendant's defense. If the prosecution's case cannot give us, an overwhelming proof beyond reasonable doubt, the court have no business convicting the defendant. Okay? That is the second issue because there are three. The third one is the issue on jurisdiction. Nnamdi Kanu, when he was called to enter his defense, raised an objection. In law, we call it preliminary objection. The law is that objection can be brought at any time before judgment. Even if the court has written a judgment, you can file a motion and say that you are objecting to something about the case. He brought that objection and said the court does not have jurisdiction to try him on certain grounds. And in law, once jurisdiction is an issue, once the issue of jurisdiction is raised, the court will have to suspend whatever it is doing and attend to that interlocutory application. Because the interlocutory application has to be resolved first before you go back to the substantive suit. So at the point when Nnamdi Kanu raised that issue, no matter how long the case has taken, the judge is supposed to hear that motion first. Because the issue of jurisdiction, once it is raised, the court must first of all assume jurisdiction to determine whether it has jurisdiction or not.
All right, so you have
That was shelved aside.
Okay.
So on the basis of these three interlocking principles of law that was violated, no conviction can stand appeal when the trial court have erred in law by violating these fundamental principles of law. So it's not about sentiment. It's not because it's Nnamdi Kanu that is involved. If it were any other person, the same analysis I'm doing is what I will do. I do not have interest in whether it doesn't matter who's involved, whether it's from east, west, or south. There is a miscarriage of justice, and we must accentuate it.
So the judgment did not meet up with your expectation. First of all, I think you raised the issue of technicality, the fact that the law upon which he was charged or convicted is an old law, that the prosecution should have amended the charges to fit in with the current law. And second of all, you said the prosecution did not call any witness. And third of all, you said the issue of jurisdiction was not dealt with effectively. So when you look at all of these three things you have mentioned, the question will be, why did the judge go ahead with his guilty verdict? Can you rationalize his own argument in coming up with that guilty verdict?
Yeah, I read the judgment, about 144 pages. Okay, lengthy judgment that made certain facts and issues around it. Okay, the judgment was principally delivered solely because Nnamdi Kanu did not enter a defense. So all the allegations of the prosecution was admitted and relied upon. Okay, even when they were defective. Okay, because the truth is this: in criminal prosecution, once the prosecution ends its case, you have three options as a defendant. One is to file a no case submission. Two is to enter your defense. Or three is to rest your case on the prosecution's case. You understand?
Yes.
So, but the fact that you are resting your case, in the case of Nnamdi Kanu, because he didn't file defense, by law it is deemed that he rested his case on the prosecution's case. But the principle here is that even if you are resting your case on the prosecution's case, it is not the court's duty to just take hook, line, and sinker the evidence of the prosecution and rely on it and pass judgment without looking at the credibility of the prosecution's evidence, which was also largely discredited during cross-examination by the defendant. You know, Kanu Agabia said and did the cross-examination in that particular. So, the court couldn't have reached the judgment of guilt in the presence of fundamental defects. Fundamental defects in line with the principles of law. You understand? So, wherever it is, anywhere you take it to, wherever they take it to, those issues must be addressed before you can find conviction. But there's no way you can match Atus Reus and Mens Rel, okay, and arrive at the conclusion of guilt without taking care of those primary issues listed. And that is why I started this analysis by outlining those interlocking defects which were not taken care of. So, if a man decides not to enter defense, it does not solely mean that the prosecution's case is valid.
Well, let me just read out what Justice Omotosho said in view of what you just said in terms of not entering his defense. He said that Justice Omotosho on his own said he begged him to enter defense, but he refused, saying that shows that he chose to rest his case of the prosecution, which is a gamble and a risky action. which is a gamble and a risky action. But you are saying, despite the gamble nature and the risky action taken by the defendant, the justice should have, in his own capacity, queried the veracity of whatever it is the prosecution was bringing in terms of maybe the witnesses, whether they were there to testify to what Nnamdi Kanu was alleged to have been culpable of. But then again, when you look at the fact that he didn't enter defense, how is he going to go about it at the appeal court? Since he didn't enter defense, how is he going to argue some of those things you are bringing on board at the appeal court?
Yeah, it's going to argue. It's just that it's going to put more pressure on the lawyers because the appeal court, in the appeal court, you don't call witnesses.
Okay.
In the jury court, it's a court that will look at what the lower court did. Only look at what the lower court did. And if there were errors, correct the errors. Okay? So, Nnamdi Kanu cross-examined the prosecution witness that was called. Okay? Now, because there was cross-examination, okay, there's something that the defendant has deposited in the trial, even though not defense. Because cross-examination in a way is to discredit the case of a prosecution, and then a defense is to disprove the evidence of the defense. Okay, so there's something we wish to stand on, and basically the appeal is principally based on procedures of law.
Okay.
Errors made, yes, not as to document filed or not filed. So they are basically legal and procedural errors, okay, which in couching an appeal can be couched directly to say that the Ghana trial judge erred in law when he, took the following decision. You state the grounds of appeal and the particulars of appeal, okay, and the particulars of error rather. So they'll couch it that way and then argue principally on the procedural aspect of law, which is very fundamental. Every court is bound by legal procedures. A court cannot go on a voyage of its own, on a frolic of its own, to reinvent the law and then come up with a judgment. You have to go through, lay down procedures. There are principles, and these principles will be followed. So if you have violated those principles, the appeal will correct it. And that is what I think should be done. The two options open to Nnamdi Kanu is the appeal, formidable appeal, and presidential pardon.
So at the moment, what you're perhaps saying is that he's going to be counting on the procedural errors, in quotes, procedural errors.
Yes.
Okay. But looking at the case on his own merit, in view of what some persons are trying to make out of the case, they said the evidence brought cannot stand because Nnamdi Kanu himself did not carry arms, he did not kill anybody, and based on that, he cannot be convicted. In their own estimation, because I saw a report by IPOB saying that, indirectly saying if you commit terrorism, you must be directly involved. But because Nnamdi Kanu did not carry arms and what have you, and then the judgment is faulty. So I'm trying to understand, what does the Terrorism Act expect before somebody can be said to be culpable of terrorism? Does a person have to physically cause harm? Or can we base it on what Justice Motosho said, that intimidation and broadcast through radio caused harm, and so is enough for the defendant to be found culpable or guilty?
Nnamdi Kanu's activity is very far away from terrorism. Very, very far away from inciting the public, making broadcast. Even though the Terrorism Prevention Act had expanded the scope of terrorism to mean when you recruit people, okay, to carry out an act of violence, okay, or when you incite people to go to a place and destroy things or kill people or threaten people, okay, or bring them under apprehension or intimidation. The Terrorism Prevention Act have expanded the scope. You understand? But what the evidence before the court? There is no evidence in the court that was directly or unequivocally linked to Nnamdi Kanu. And the link to the activities of violence that happened thereafter. You understand? Someone make a statement, okay, and then you don't have any unequivocal evidence or nexus linking him to the violence. Talk about that what he said led to killing of women at the NSAS. What do you mean by that? The NSAS, this is started independent of anybody's pronouncement.
Okay.
And when we were protesting at the NSAS, there was no leader, nobody was instructing anybody.
Okay.
The NSAS didn't have leader. Nnamdi Kanu was not significant. The NSAS protest. Okay. It wasn't even in Nigeria, you know. So to now say that it the NSAS that led to whatever, I mean, it doesn't hold water. Because then you now say that it's a broker led to the king of soldiers and the rest of that and the politician and so many things. Just like that. Just like that. You don't have any credible witness. You didn't prove the case. You understand? So anybody that died at that time, it was not the kind that caused it. We should be reasonable sometimes when the law is not sentiment. Okay. Law is not sentiment. You don't convict people like that just because you want to serve a cause or you want to promote government or whatever. You don't convict. A penalty that is capital, you don't handle it that way. Okay. Well, I'm saying all this because of posterity. Right. I cannot be a lawyer in Nigeria and then keep quiet. I will see this kind of trial and then I've followed these trials in 2015. First of all, the extraordinary rendition already does not even warrant any court in Nigeria to undertake this matter. Because it was illegally brought into the country. You understand? And when you look at that rendition, it flouts all international treaties and protocols, even the Geneva Convention. So then you now brought him in the court as to release him. You left him in detention, went on appeal, then went back again to start the case from the court of the Federal High Court again. And then all of a sudden they are convicted. They don't have a convictable. So the whole thing about the case for me, as they said, as a political case, they should have resolved it through political means than to the court into this whole without judgment have no ground at all. You will see how it will be thrown out on appeal. It will be thrown out, the court will throw it out. I don't want to preempt the court, but we're not trying to do that. Right. But I know that judgment cannot stand the test of that.
Yes, just a quick one. Thank you very much for coming in, Mr. Ufeli. Just a quick one. Since you said that judgment was based on a repealed act, as it stands now, the issue has gone to they are traveling to the appeal court now. So, two questions. Number one is that the prosecutor, does he stand a chance of amending whatever that must happen, since that judgment was given based on a repealed act, can they do anything about it as it stands now? That's one. Two, in the political side of this issue, how can it be handled? What is the best way to handle it? Because we have, based on what you've said, you projected that, okay, there are two options, right of the appeal and, of course, the political pardon or thereabout. So, can this be done? How can it be done based on the political aspect?
Okay, the first question is this. Answer to the first question is that neither party can amend anything again. Nobody can amend or file any fresh evidence. Nobody can file, amend, because it's not a trial court. Court of appeal is a jury court. It only looks at what has been done. You cannot go and correct what has been done now. Correct it. No. You can't file anything other than your appellate brief and then your records of appeal. That will be compiled. The court is going to compile records of appeal. And what the record of appeal means, all the documents tendered and used at the trial court, everything will be compiled. So you cannot correct anything. You are not correcting anything. The court of appeal wants to look at what you did, whether it's right or wrong. So the time they would have amended it is gone. You cannot amend anything. When they would have amended it is gone. They cannot amend anything now. Either side, both sides. Then the second question. This case is highly political. That is even why it went. That is even why there's a conviction with it. Otherwise, you and I know that nobody is convicted like this. Nobody is convicted like this. No evidence, nothing. Just the trial was so funny. It's like the way Jesus was tried. Everybody just stood. And they say blasphemy. For blasphemy, they take him to Aaron, they take him to Pilate, take him, I don't have jurisdiction. Take him to this one laugh, take him to that one, then the next thing, crucifixion. There's no evidence. That's why even a lawyer in Kenya went to court not too long ago to challenge the Roman government and the ICC for putting Jesus Christ to death without a proper trial. So, you see, the case is that this is a political case that they should make an application through the Attorney General of the Federation to ask for presidential pardon. And the leaders of the Southeast will need to be at the forefront of this. This is not the time to play politics, or the time to show that to use the who have used this case to play politics, and the rest of that. The leaders of the Southeast are very influential people. They are widely traveled and they know what to do. I mean, my advice is not watertight, but it is critical, I say, because their input will go a long way to see the resolution of this matter. The application should be made through the Office of the Attorney General for presidential pardon, and it should be made while the appeal is ongoing. Because nothing in the law says you cannot apply for pardon while you are filing an appeal. So while the lawyers are doing their case and the appeal level, the leaders of the eastern part of the country will make that application and follow it up. You understand? Because it's only the president that can grant this by law. Section 175, prerogative of mercy. The president can either wipe off everything, will become a free man, and he will not be referred to as an ex-convict. Or the president can reduce the term or whatever it is he wants to do. So that is the two-punch approach that the people can take in the case of that reference.
Well, thank you for your insights so far. If you have just joined us, we are speaking with constitutional lawyer Barrister Evans Ufeli, who has been taking us through the case of Nnamdi Kanu, helping us to understand the processes, whether the processes were duly followed or not. Part of his revelation is the fact that procedural errors were observed in terms of the law used to prosecute Kanu, in terms of witnesses not obeying code. And of course, he talked about the chances of Kanu at the appeal court, saying that perhaps what he perceived to have gone wrong at the lower court, based on how the prosecution handled it, could also serve him as an advantage. We'll wait and see as far as that one is concerned. But Barrister, let's look at, you rightly pointed out something, which is there were events were happening on their own during NSAS outside Nnamdi Kanu. And so it's almost, illogical to associate him with the damages done during the NSAS. But some people would say, what about people who had been testifying here and there in view of what his pronouncements caused in the Southeast? How do you excuse the fact that there are people who are saying, because of this directive he issued during his broadcast, that's why maybe I have a relation who died during the time, maybe after NSAS, not necessarily during that period?
Yeah, I saw there's a group, and I saw on TV, they said that they are not part of the secession narrative, and that the orders he made led to the demise of many persons and all that. You see, that is an allegation. Why didn't they go join the trial and be witness? That's the sentiment I'm talking about. Assumption. Okay, you are where your relative got killed at that point, and the prosecution was doing their case. You didn't go to be a prosecution to tell them you want to be a witness.
Okay.
Then after everything, you're not carrying flag, and you go to an ice cream and be carrying flag. You're saying your relative, some of your relatives died. That's not the solution. Because the thing is this, you should have brought those relatives who are, or you as a person, could have gone to be a witness. By the time you testify and you are cross-examined, you will now know what it is you are talking about.
All right.
Not that you didn't come out as a witness, you were not really
all right, Barrister, because we are almost out of time, let's quickly hear from this person before we go on. Are you there? Good morning. All right, please, quickly. Right. Please go ahead, make it quick. Okay.
Nigeria is almost lawless country that the Supreme Court will say it doesn't matter how somebody came into the was working and let the invest trial. I don't know that Snowden was picked up by America in any country. You know that they ran to Russia. That anybody is telling me that America cannot try him. Because of that lawlessness, our highest court in the land is that some people claiming that Malthus as a lawyer will be condemning us to court, trying to give some hope to some people. This is an Odenigbo man, that's why I say that I will come back to the advice. We said that we are poor blood. The case that we're talking about is a case that involves a lot of people that died, even from the side of the person that was inciting the public and from the innocent souls that we are killed in the name of the Diasapo. And people are not factoring in the souls that was wasted. They are not even thinking on how to bring justice for these people that are calling for justice. As an Igbo man, I think anybody maybe trying to speak against those people that died, the consequences will be unimaginable. As an Igbo man, I urge my fellow Igbo people to disease if they will heed to what I'm saying. These people that died, they are so if you stand on their way, the consequences will be unimaginable. As far as I'm concerned, incitement, carrying ammunition, because there's most of them saying that they will quickly tell you that let the federal government go and arrest me. Let the federal government go and kill Boko Haram. And the same type of killing, murdering is happening here, but they will look away. Let me stop here.
All right.
Thank you.
Thank you very much. Barrister, I don't know if you heard him and if you have any reaction to that.
Yeah, I heard him not very clearly. But he was talking about those who were killed during those incidents.
Yes, that some people are living in denial of such killings.
Nobody is saying people didn't die. You see, people died. There were crises, there were violence, and the rest of that. But you see, when you are talking about criminal prosecution, it's not enough to say people died. When you saw of those who died, rest in peace, the prosecution ought to have gotten witnesses to accentuate all those evidence. You understand? So it shouldn't be hearsay. That's not to say we don't have our heart will not go to those who lost their lives and their relatives. That's not to say so. But I'm saying for the purpose of the prosecution, you understand what the prosecution ought to have done, not like us support the death of those who, what the prosecution ought to have done, they didn't do, you know what I'm saying?
Yeah.
So, that's it.
All right. Before we wrap up, there are some groups also saying that the judge allegedly manufactured his own charge in view of labeling Kanu an international terrorist, saying that his broadcast said that they should bomb American embassy, and of course, I think the UK ambassador at the time. How do you measure this alleged contradiction? The fact that the judge says something that was not in the charge, because we have 7-count charge, and they're saying nothing like that was in the charge. The judge allegedly manufactured his own charge. Did you spot that argument? What do you have to say about it?
It was misleading. It was misleading for the court, for the judge to say that. It was misleading to say this because when you are trying a defendant, they will try a defendant within the ambit of the charge before the court. Anything outside the charge before the court is not acceptable. So I think those ones go to no issue. And a judge ought not to send into the arena of conflict. That's what we are taught in law. So but when you start to create extraterrestrial charges around the substantive charge, then it means that there's partisanship and extending to the arena of conflict itself is not a good thing for a judge to do. So I think those issues, it goes to no issue.
Okay. We can't wait to see what the appeal court says, but it has been an insight from you, Barrister Evans Ufeli, constitutional lawyer. Thank you for your time. You joined us virtually all the way from Canada. Thank you for agreeing to this interview. We appreciate.
Thank you. My pleasure.
All right. Have a great day. All right. All right. There you have it, Nigerians. Some legal perspectives there as far as understanding it properly is concerned. And of course, the lawyer spoke from expertise opinion, nothing emotional, and it was a revelation. So I want to appreciate him, and of course, I hope you've been able to take out one or two things. Wait and see what the appeal court says and who ends up with the upper hand. But that has been the show for today. I want to appreciate everybody who listened and of course joined the conversation. The conversation will continue next time. Till then, my name is Njideka. See you again.